All right, this is case number 253963FY. The people of the state of Michigan versus Corey James Waite. Mr. Waite, did you have the opportunity to meet with somebody from the defender's office today?
Yes, I did.
And I see that you met with somebody from Community Corrections. Is the address on Cody Street accurate?
Yes, sir.
And a phone number ending in 8151?
Yes, sir.
All right. I have a complaint that alleges that on or about September 4th, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of police officer assaulting, resisting, or obstructing. That is a felony punishable by up to 2 years in prison and or a fine of $2,000, and a consecutive sentence may be imposed if it happened in a place of confinement. Additionally, the prosecution has elected to charge you with a habitual fourth offender notice. That means that you have at least 3 prior either attempted or completed felonies in your past. That makes that 2-year felony up to a 5-year felony. Do you understand that? I'm sorry, 15-year felony.
Yes,
So it
sir.
makes a 2-year a 15-year felony. Do you understand that?
Yes, sir.
Felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes, sir.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I believe request the appointment of attorney.
And what is your current source of income?
I have none.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the crime. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be ordered to stand trial in circuit court. Do you understand that?
Yes, sir. Aren't I supposed to have an attorney here?
I'm sorry?
Isn't there supposed to be an attorney? Oh, okay.
Mr. Harrison's in the courtroom.
Okay, I thought that was the prosecutor. Sorry.
Prior to the preliminary examination, there'll be a probable cause conference, which is a way, it's a hearing in which your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, Mr. Harrison, I show in 03 as a juvenile, a home invasion second, and larceny in a building. In 03, an attempted home invasion second, and an attempt and a home invasion third. In 07, there was a B&E with intent. 09, larceny by conversion, less than 200. In 12, there was an attempted home invasion second, use of a controlled substance. In 11, there was an attempted larceny in a building. In 11, a larceny less than 200. 13, larceny less than 200. 15, retail fraud second. 15, possession of narcotic less than 25 grams. In 17, delivery or manufacture of a controlled substance schedules 1, 2, or 3. In 23, there was a retail fraud third, and I show that the defendant is on parole until, looks like November 13th. The praxis scores him at a risk level 4, so medium risk. Any comment regarding bond?
Well, yes, Your Honor. He's currently enrolled in truck driving school. He wants to be able to finish that so he can gain employment that way. As you elicited from him, he's not currently employed. He has 3 children at home. I'm not sure exactly what happened. I believe it has something to do with his parolee status, and I presume parole is a hold on him anyway. To that regard, I would have you set a low or PR bond just so we can establish something. If you set PR, he doesn't get credit. He's sitting dead time anyway. We need to sort some or all of that out. It's going to be a minute before we can.
Corrections, is there a parole hold on the defendant?
Yes, Your Honor.
All right. I'll note for the record that the prosecutor's office does not appear, nor has there been a filing for bond conditions requested. Without knowing more, I do find that the defendant is at least a threat and flight risk, given that this is a resist and obstruct charge. The fact that he's on parole, I believe, indicates that a monetary bond is appropriate. The court will set a $5,000 cash surety bond. Mr. Waite, you are to appear as ordered, keep your contact information current, not leave the state without permission, and commit no new crimes. Additionally, I'm going to order that you not act in any threatening, intimidating, or harassing behavior. Do you have any questions for me about your bond conditions?
Can I ask a question about bond? Just a question in general.
Sure.
In my whole lengthy record that I have not one violent crime, which at 36 years old, I'm not going to get violent. Yesterday, and I know you're not the judge that gets to determine this, but I'm not whatsoever. I have a flight risk for anything. And being on parole, I would be more obliged to go to court. I have never once raised my hands toward anybody, and I don't understand what happened yesterday happened to end up in these charges, period. I'm the one who got hurt out of asking for a kiss from my wife. But is there any way to even implement a 10% so I can afford it, so I can try to work something out with getting out on bond, possibly for treatment? I have ties with my wife, and my mother-in-law are sitting in the courtroom. I have support in the community. I'm trying, I know I have a bad record, but in the last 5 years, I've been the best I've ever been in my life. And it's out of the help from them two people sitting right there, honestly.
Mr. Waite, until I know more, I'm going to keep bond where it's set at. However, your attorney, whoever your attorney is that gets appointed to you, will know how to do a motion for bond reconsideration. And if they do that, the court will hear that and make another determination. All right.
I appreciate it.
All right. Thank you. Next arraignment, jail. A person at the jail, what is your name?
Ryan Smith.
This is case number 253962 SM, the people of the state of Michigan versus Ryan Ray Smith. Mr. Smith, you met with somebody at the Community Corrections Department today, and they took some contact information from you. Is that information accurate?
Yes, sir, it is. I do have a stable address as soon as I get out. Like I told him, I was supposed to be at work at 2 o'clock at Ruby Tuesday today. My boss, Rick, said I could throw my tent in his backyard and use his address because he knows what has happened.
Okay. Do you know that address?
I do not. No, I have not had a chance to use the phone. I do not have his direct number either. At least not until I get to work.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes. Yes, Your Honor.
I have a complaint that alleges that on or about September 4th, 2025, in Herring Township of Wexford County, it is alleged that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500, and consecutive sentencing may apply if it happened in a place of confinement. Do you understand those charges and the potential penalties?
Yes, Your Honor.
Did you review and sign an advice of rights form at the jail, talk about your rights to an attorney and your rights to a trial?
Yes, Your Honor.
Did you understand those rights?
Yes.
You do have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you, but you may have to repay a portion of that expense. Do you understand that?
Yes, Your Honor.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'd have to go with the request of the appointment of attorney, as I literally just started. I've only lived up here for 2 weeks. I came here just to make something better myself, do something. I have 2 daughters I take care of back down in Owasso and Flint. So I haven't had much time to get a job. Like I said, Rick, the main manager, the GM of Ruby Tuesdays.
Okay, Mr. Smith, my only question was, do you want an appointment of an attorney?
Yes.
All right. Then the court will make a referral to the public defender's office for the appointment of an attorney, will enter not guilty plea on your behalf, and will set the matter for a pretrial. That's a hearing here in the district court in which your attorney and the prosecuting attorney will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Mr. Harrison is here from the defender's office. Mr. Harrison, I show in 2012, there was a larceny, 200 to 1,000, and 17 malicious destruction of property less than 200, 19 an attempted disorderly person, 19 a disorderly drunk. There is a bench warrant out for a child support case from 24, and there is a no contact with the alleged victim in this case that was issued on June 6th out of the 91st District Court. Any comment regarding bond?
Well, our immediate concern is that he needs medication. He's had a fairly recent spinal surgery, of all things. He is up here to obtain employment, as he indicated to you. He does have work at the Ruby Tuesday here in town. He was supposed to start in about 12 minutes. Other than that, Your Honor, doesn't look like there's anything substantial in his background. He does have a stable address. He tends to observe his employer's commitment to have him work at the restaurant and pay his child support. I don't know what the warrant status is on the child support case, which might make it interesting too, but he is. I don't know if there's a bond internally on those.
The bond is generally the amount owed.
In felony child support cases, if the bond is set statutorily, and we may be in the position of enforcing another court's bond order at this juncture, I don't know. Based on the facts here, I think he's a decent candidate for PR based upon his limited resources and his desire to return to work.
So it looks like the cash bond on the child support case is $500.
Okay. That's 91st.
No, that is the. It's Tuscola County.
Tuscola. Okay.
The no contact order, which appears to be a bond condition on a domestic violence case, is out of the 91st, which I believe is Sault Ste. Marie. All right, I'll note for the record that the prosecutor's office does not appear, and nor has he filed a request for bond conditions. While the defendant does not have any violent convictions in his past, it is concerning to the court that there appears to be a domestic case pending out of the 91st District Court, in which I can only assume, because of the no contact order, that the alleged victim in that case is the alleged victim in our case. So I do find the defendant as a threat Bond will be set at $10,000 cash surety. I'll change that to 5,000 cash surety, given employment status.
Your Honor,
That
may I
he,
speak?
Mr. Harrison? Do you want him to speak?
At this point, my office does not represent him. I would prefer, obviously, that he not do so, but he's essentially unrepresented.
Mr. Smith, I want you to say nothing about this case that's pending or anything factually about the case that's pending up in the Sioux. Do you understand that?
Yes, Your Honor.
Okay, what is it you'd like me to know?
Sharada Woodring had followed me up here. She's got cases. She has had a plea to a domestic against me downstate.
No. I'm not gonna let you sit there and tell me all the things the alleged victim has done wrong. I'm only concerned with what your record shows.
Yes,
All
sir.
right.
Yes, sir. That's why I don't plan to have contact with her in any way ever again in my life. This is, as you see, this has happened a couple times, and I don't plan to have any contact with this lady. The only reason I came up here is to literally get a job and help with my child support. And I'm also going through the court stuff with Sault Ste. Marie. So, this way I'm closer and I can still attend my court dates there as well.
Well, I understand that, but based on what the court has in front of it today, all I know is there's a domestic violence case pending in which she's the victim with a no contact order, and then you pick up the case here, and I'm not finding you guilty today, but you pick up the case here in which she's the alleged victim again, and now you've got that issue and now a potential bond violation. So as I was saying, bond will be set at $5,000 cash surety. Mr. Smith, you are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm going to order that you not have any contact with Sharada Woodring. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. Additionally, you are not to purchase or possess any firearms or weapons, and that you not act in any threatening, intimidating, or harassing behavior. If you are found to be in violation of your bond conditions, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yes, Your Honor.
All right. Thank you, jail. Do we have a complaint on the other one? And we do have the complaint on the other file, so if we can have him.
Yes, Your Honor.
All right, sir. What is your name?
Jason Hornung.
This is case number 253964 ST, the people of the state of Michigan versus Jason Ryan Hornung. Sir, you met with someone from Community Corrections today and gave them some contact information. Was that address and phone number correct?
Yes. I'm not gonna lie, the phone number's new, so I might have mixed it up, but I think I gave both variations of it so that we could get it worked out at some point. But that is my address.
So it looks like it's either, I can't necessarily read the right, it looks like 0657 are the last four digits.
I think so. It's either 0657 or 0675, one way or the other. I've only had that number for a couple weeks.
All right. Did you have the opportunity to meet with somebody from the defender's office today?
Yes. Well, they took me to meet a
Mr. Harrison, did you
public,
meet-
yeah, public defender, sorry.
All right, you did meet with
apologize.
somebody?
Yes,
All right. I have a complaint that alleges that on or about September 4th, 2025, in the city of Cadillac of Wexford County, it is alleged that you committed the offense of operating while your license was suspended, denied, or revoked. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500 and vehicle immobilization is possible. Do you understand those charges and the potential penalties?
yes, sir.
Did you read and sign an advice of rights form at the jail, talk about your rights to an attorney and your rights to a trial?
I believe so.
Do you believe so, or do you remember doing it?
I signed a lot of papers.
All right, so I need to make sure you understand your rights. I'm going to go through them with you, all right?
Okay,
If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please contact the court immediately to make those arrangements. You have been brought to court on a misdemeanor charge in the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. To have a trial by jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money to hire an attorney. And if the offense charge requires a minimum jail sentence, or the court determines that it might sentence you to jail, the appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require witnesses to come to court, to see, hear, and question all witnesses against you at trial, to be a witness for yourself or to remain silent, to not have that silence used against you, and to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you'll be giving up those trial rights that we just went through. You also have the right to be released on bond, and we'll get to that in a moment. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days from the date of sentence, or is permitted pursuant to court rule if the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. Federal law and or state law may prohibit you from purchasing or possessing ammunition or a firearm, including a rifle, pistol, or revolver. If you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Do you understand those rights as I've read them to you?
Yes, Your Honor.
As I said, you do have the right to be represented by an attorney, and if you could not afford one, one would be appointed to represent you at public expense, but you may have to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'd like to request the court help me with an attorney.
And what is your current source of income?
Self-employed.
All right, court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf, and will set the matter for a pretrial. That is a hearing at which the prosecutor and your defense attorney will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Mr. Harrison, I do not show anything in the defendant's criminal record. However, the praxis scores him at a risk level 2, which is low risk, and does note that he currently has a case pending in Grand Traverse County for possession, looks like a peewit of meth and some sort of weapons offense with that. And it also states there was a marijuana charge which was expunged, and that he was on bond. Any comment regarding bond, Mr. Harrison?
Well, obviously, this is a lower level offense for which he's before the court here. He's already under some form of supervision on bond or otherwise in the courts of Grand Traverse County. I presume he is determined to participate in that cause of action. I see no risk to this court releasing MPR.
Thank you. The charge that the defendant has been charged with carries with it a presumption of no jail or probation. I'll note for the record that the prosecution is not here, nor have they filed any requests for bond conditions. So without knowing more, the court sees this simply as a driving license suspended, denied, or revoked, and the court will issue a personal recognizance bond. Mr. Hornung, you are to appear as ordered, keep your contact information current, not leave the state of Michigan without consent, and to commit no new crimes. Do you understand that?
Yes, Your Honor.
Before you're released from jail today, you should be receiving your next court date. Make sure you make note of that. And then you should be hearing from the public defender's office within a few days. Okay. Thank you, jail.
Thank you.
You're welcome. Have a nice day.
All right, let's talk about that. This Wexford County arraignment gave us 3 very different defendants, 3 different charges, and a judge keeping the tone steady but serious as Corey James Waite, facing assaulting, resisting, obstructing a police officer. Normally that's a 2-year felony, but with a habitual 4th enhancement, it jumps all the way to 15 years. Waite, already on parole, asked for a court-appointed lawyer and tried to argue for a lower bond. He pointed out he's never had a violent conviction, has family support, and is in truck driving school. The judge wasn't swayed, noting his long record, parole status, and the fresh resist obstruct charge. Bond landed at $5,000 cash surety, with conditions to avoid threats or intimidation. The judge left the door open for a reconsideration motion later, but for now, Waite stayed locked. Next was Ryan Ray Smith, charged with misdemeanor domestic violence. Smith's record was light but checkered: past larceny, property damage, and a disorderly drunk. More concerning was that he already had a no-contact order with the same alleged victim in another county. His defense argued he was up north to work, starting at Ruby Tuesday that very day, and recovering from back surgery. The judge balanced the sympathy against the red flags and set bond at $5,000 cash surety with strict no-contact terms, emphasizing that any violation could land him back in custody immediately. Finally, Jason Ryan Hornung faced operating while suspended, a low-level misdemeanor. He admitted confusion about paperwork, but was polite and cooperative. His record showed no convictions in Wexford, though he did have pending meth and weapons charges in Grand Traverse County. Despite that, the judge recognized this was just a driving case with no presumption of jail. Bond was set at personal recognizance. No money down, just show up and stay out of trouble. The atmosphere across all 3 cases was calm but pointed. The judge handled Waite's pleas for leniency with patience but caution, listened to Smith's long backstory before cutting off attempts to blame the alleged victim, and let Hornung out with the lowest bond possible. 3 different defendants, 3 different outcomes, all tailored to the charge and the risk. Time to break this one down. Waite walked out with a stiff bond and a long record weighing him down. Smith got a mid-level bond and a strict no-contact order, and Hornung left on his own recognizance for a suspended license. Same bench, same morning, 3 very different paths. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.